Good afternoon, everyone. Welcome to today's meeting on May 28th, 2020 of the Chief Justice COVID-19 Judicial Branch Task Force. My name is Don Bridges, and together with Judge Jay Corpening, I serve as co-chair of this task force. At the outset of this meeting, as is our custom, I remind everyone that today's meeting is subject to the North Carolina Open Meetings Law and is being live streamed so that it is available to the public and members of the media as we go along. For those of you who are joining the meeting only by telephone or audio connection and not by video, when you speak, please remember to identify yourself by name so that everyone listening in will know who is speaking. Now, at this time, let's begin with a roll call for those who are present at the meeting.
Judge Bridges, you're here. Judge Corpening?
Present.
Judge Vincent?
Present.
Mr. West?
Present.
Mr. Evans?
Present.
Clerk Johnson?
Present.
Clerk Shingari?
Present.
Kinsley Craig?
Present.
Kelly Myers?
Present.
Jason Cheek?
Present.
Jennifer Harjo?
Present.
Mr. McCabe?
Present.
Mr. Harrison? Mr. Harrison, was that you?
I'm present.
Mr. Weed?
Present.
Judge Sermon?
Judge Sermons notified me that he would be unable to attend today.
Okay, and then the only other committee member is Mr. Keister, who has sent us a note that he won't be able to join until 3 p.m. So I think you have everyone who will be here for now.
Our next item will be consideration of minutes from the meeting last week on May 21st. Those minutes have been circulated for review by members of the task force. Is there anyone that wishes to offer any corrections or additions to those minutes? Is there a motion that those minutes be approved as circulated?
Teresa Vincent, I motion that we adopt the minutes as circulated.
Thank you, Judge Vincent. Is there a second to that motion?
Billy West, I'll second that.
Thank you, Mr. West. Could we call for a roll call vote, please?
Judge Bridges?
Yes.
Judge Corpening?
Yes.
Judge Vincent?
Yes.
Mr. West?
Yes.
Mr. Evans?
Yes.
Clerk Johnson?
Yes.
Clerk Shingari?
Yes.
Kinsley Craig?
Yes.
Kelly Myers?
Yes.
Jason Cheek,
Yes.
Jennifer Harjo,
Yes.
Mr. McCabe,
Yes.
Mr. Harrison,
Yes.
and Mr. Weed.
Yes.
That is all those who are present, Judge Bridges.
Thank you, ma'am. At this time, I will call upon Judge Corpening to address item 3 on today's agenda as we continue to do our work with regard to case priorities.
Thank you, Judge Bridges. Last week when we met, we had submitted a draft of the priorities. We've incorporated the recommendations on case priorities from every work group that submitted case priorities. We have woven that into the draft of the task force report that you've received. And so at this point, if there's any substantive discussion from members of the task force, I'd invite that. We are at the point where we really need substantive input. Anytime we get this many lawyers in a room, wordsmithing can be challenging, and we would be talking about it for a year, right? So any substantive input from anyone today, but then I'll also share with you that we'll welcome substantive input through Tuesday of next week. Judge Bridges, I think that was our contemplation on this.
Yes.
So any substantive input on the case priorities as it's been set out in the draft report? Any concerns about that? All right, hearing none, then we'll invite any substantive contributions you have on that issue by close of business Tuesday. It's set out in the draft report. The draft report may be updated as a result of submissions today from our two of our working committees, and so please review it and then give us your substantive input by Tuesday close of business. Judge Bridges, back to you.
All right. Thank you, sir. Our next item for consideration will be to receive updated reports from our committees, our working groups. The first of those is the Best Safety Practices group, chaired by Kelly Myers. Kelly, do you, in addition to the written report that has been provided today and circulated, do you have an oral report that you would like to make as part of today's meeting?
Thank you, Judge Bridges. I will try to keep it brief because our report is not very brief. And I just want to start off by saying thank you to everyone who was involved in helping pull this together. It was no easy feat. And I think sort of in reading the introduction of the main task force report and thinking about our directives from the beginning, which are really to provide clarity to the field, I think the introduction actually says that courts need to have clear and consistent messages about safety precautions. And so I just ask the task force members, as you review this, to keep that in mind. And if there's information in here that is not providing clear or consistent recommendations, or at least recommendations so that local officials can make clear and consistent decisions, then please, provide those comments and the input by next week. I think the deadline is going to be Tuesday. And the other is really that our decisions throughout were guided by the hierarchy of controls. And the reason being is that, again, for that consistency and clarity, that while we provided many pages of examples and suggestions and thoughts, that really you should be able to go back to the hierarchy of controls and figure out what's most effective or what combination of those controls will work for your local courts. I don't have anything else really to add on that. I don't know if any of the members of the of our working group wish to comment.
Is there any other comment either from any other member of that committee, that working group, or any other task force member with regard to today's report from the Best Practices Working Group? Let me say one other thing. We have made a couple of references to a deadline. In trying to decide upon what might be a workable approach to receiving and giving fair consideration to comments concerning possible editing of the committee reports, as well as the report from our task force. Judge Corpening and I have agreed that perhaps the best approach to that would be that if we give everyone an opportunity during the next few days to read and consider all of this information. We've got lots of written materials to which we need to focus our attention. And if we take a few days between now and Tuesday to consider all of that information, and if you have concerns about information or feel that we need to reconsider or have some discussion among the entire task group as to particular aspects of these individual reports or our task force final report draft that we're working with right now as a whole, please make those comments in writing with a request that they be included on our agenda for our next meeting as an item on the agenda for discussion, so that we can have advance notice of that and be prepared to deal with those. And really the purpose of that is hopefully to provide a little more structure to how we go about considering further edits to the individual working group reports, as well as to the comprehensive report that the task force is working on putting together. So please note that if you wish to address those topics, please include a request for that in writing no later than Tuesday, June 2nd at 5:00 p.m. in order to allow sufficient time to include those items on the agenda and to be circulated all in advance of the meeting. Any further comments or questions about best safety practices?
This is Danielle. I just wanted to ask that if people do submit comments, if you please make sure you copy me on the email so that I can get it all organized for the next meeting. Thank you very much.
That is a very important point that I somehow failed to mention. Thank you, Danielle.
No worries, Your Honor. Thank you.
All right. The chair of the Technology and Innovation Committee is Judge Chuck Henry. Judge Henry notified me in advance of the meeting that he had court obligations that would prevent him from being able to attend today's meeting. I believe that Judge Alan Bedour is prepared to report on behalf of that working group.
Yes, sir. Thank you, Judge Bridges. We did, I think you all got our report yesterday, and I won't walk through it, but just sort of highlight that what we tried to do was, address some of the main issues that we thought we could address through the use of innovation or technology. And so you start thinking of things like scheduling and notice, and how we address high volume court operations, and also communication. So communications both, in a court proceeding, but also things like a criminal defense attorney talking with someone who's in custody. And so we also tried, when we were going through those recommendations, to sort of stay out of the weeds and make a recommendation, for example, that improved communication between defense counsel and clients in custody, be addressed, but not talk about a specific platform to do that, because we wanted to give the task force as much freedom to explore, and AOC, of course, to explore, different platforms and ideas, and not necessarily have us latch on to something because one person had used it or another, and so forth. And I guess the only other comment to make is that it's sort of, we saw it as a menu of many options that the task force might choose to adopt and pass on to the chief. And then, of course, that she might choose to adopt or reject as she sees fit, and as she sees fit. And then finally, that if there are items that we've put on this, I think we and maybe all of us are sort of looking at things as short-term, immediate projects or ideas or tasks that could be accomplished either with little cost or no legislative change or things like that, all the way to a middle range and then a long term. And so if it's the will of this group that some item that we've put on this list needs to be shifted to a longer term solution, we'll certainly take it back and kind of put it out and vet it out in that arena, and that's no problem. So as you all do the reading that you just talked about, Judge Bridges, over the next few days, if folks have questions about the way we've stated something or anything we put in there, we're happy to answer them. I'm sure Judge Henry would be, or I can if you have my contact information, and as can anyone else on our working group. I know there are some other members of our working group. I'll certainly invite any other comment if anyone has any to make, and answer any questions that Judge Bridges or anyone else has as well.
Thank you, Judge Baddour. Are there any questions for Judge Baddour or other members of his group?
Judge Baddour, this is Jay Corpening. I've got a question that came up in my Chiefs meeting just in the last hour. There's obvious interest from judges about doing remote hearings, and around the state there's interest among lawyers as well in doing remote hearings. But some of the chiefs are hearing that lawyers really don't want to do remote hearings. They don't like remote hearings. So any discussions in your committee about how we can increase interest in participation by our attorneys?
Perhaps should let some of the attorneys address that directly, but I will try to speak for them and say that surprisingly there was fairly consistent feedback that essentially the power should be the courts. In other words, that it's not an opt-in by one party or the other, or sort of a veto power by one party or the other, but if the court is granted the authority to do so, and perhaps there's a just cause release, that a party could make, that certainly on the civil side there was unanimity that that was an appropriate approach. There is much more discussion on the criminal side for hearings of substantive nature, doing those remotely, and certainly clearly for juries. But short of that, I think most people are comfortable most of the time. Certainly with the reading I got was that with the process we have in place now, where a defendant consents to proceeding, let's say with a plea remotely, that people feel okay with that. But so I guess, and I really pushed on that question because my sense is that there are some places around the state, perhaps my county, Orange and Chatham, and perhaps a place like Wake or Charlotte, where maybe attorneys are a little more interested for whatever reason in that approach, and that there are some other areas of the state that are, perhaps more reticent. But But I think the feeling was pretty uniform that the civil bar is ready to try it, certainly as opposed to, not getting heard. So, I guess the bottom line is that giving the court, the judge, discretion or authority to do so, kind of shuts the door on the rest of the conversation. I guess one other piece is that we've had some discussion about, judicial authority to decide certain motions or types of motions on paper only without argument, perhaps, more like a federal style or some other states do. And there was actually pretty good support for that from our lawyers on the committee. Obviously not conducting a trial on paper, and what are the right motions, I don't know, but that's another approach to get away from an in-court proceeding that can handle some portion of our dockets.
Great. Thank you very much.
Yes, sir.
I'm willing to speak to that to some extent. Judge Vincent has entered an order in Guilford County for some remote proceedings, and she can address that. There's been a fairly broad local rule entered in Randolph County that has expanded the amount or the sort of hearings that can be held remotely. I've communicated with several lawyers who've participated in Randolph County, and it was pretty overwhelmingly popular. And I sent out a blog to the family law section of the North Carolina Bar Association, and stated in there that there would be they could expect enhanced and expanded use of remote hearings, and I haven't gotten any pushback from that. So I would also offer that I've looked into Texas family law. Lawyers there have been using remote trials and hearings, and their experience has been pretty popular. So that's all I can add to this conversation.
Your Honor, this is John McCabe speaking on behalf of NCAJ. Judge Bedore did, I think, an absolutely great job summarizing some of the discussions, but just to put a little bit more meat on that, Mr. Keister, who's unfortunately not on the call right now, he and I have been working very closely, and there is a consensus. We have both surveyed the defense bar and the plaintiff's bar, and there is a pretty strong consensus. The vast majority of both memberships would like to see these hearings proceeding in a remote fashion so that cases are not delayed any further. That has been one of the big things we've been pushing for on this task force is, moving mediations on, moving depositions on, having hearings going on. And we think doing these remotely is the best way to do that. We think it's the safest way to do it. We think it will also prevent a substantial backlog. We do want to get the cases going. The concern that we had is the court did not require it, that there would be some level of gamemanship among certain parties or attorneys where they would be using delay as a tactical benefit. And Mr. Keister and I, the plaintiff's lawyer and the defense lawyers, do not want to see that happen. And one of the problems we ran into early is when there was remote hearings being permitted only by consent. There were a lot of people who were just not willing to agree to that, and that was creating the backlog and preventing cases from moving forward. There is, again, a consensus that we want to get the cases moving forward, and because of that, the vast majority of both groups, both organizations' memberships are in favor of remote hearings.
Thank you, sir. Do we have further comments or questions with respect to technology and innovation? Our next work group is the virus fatigue work group. Jim Drennan serves as chair of that group, and I understand from Jim that he is traveling today, that he is en route to Atlanta, somewhere on I-85, and for that reason he is listening in, but will not be providing any oral report to us. And at the risk of putting him on the spot, I know that Judge Corpening has been involved during the past week with at least parts of the filming of the video. Judge, do you have anything you want to share with us in that regard?
I'll be glad to, Judge Bridges. Thank you. And then perhaps we can have some of the working group talk about some of the other work of the committee, because they've been incredibly busy. So last week, members of the judicial branch across all of our conferences filmed short video clips on their phones and have emailed them into AOC for compilation into a video, the focus of which is to make sure that we're taking care of ourselves, to make sure that we're also taking care of each other, and that we all recognize that we're in this together. As a result of the two that I filmed, the Batcave will probably be shared with, the branch, the entire branch, instead of just you guys. But we're excited about that. The video will be shared across all of our conferences, and I think will be made available more widely, because as everybody comes out of their remote offices, their living rooms, wherever they've been working and practicing isolation, we're walking back into a different situation. And folks have experienced trauma, and we need to recognize that and look out for that and take care of that. So we're excited about the opportunities that presents. The group has also gotten permission to share a poster with some simple tips about how to do a self check-in, how to recognize your stress, how to manage your stress, and just a few simple steps. And so that poster is going to be shared widely. And with that, Judge Bridges, I'll turn it back to you, and perhaps we can invite some of the other working members of that committee to talk about some of the other work.
Comments from other members of that group?
Judge Vincent, I feel like the last report that Jim gave to the committee is, fairly consistent with what he would probably say now, in terms of us being on track with everything that has just been said, and also, solidifying and compiling the information that we've gathered, as he indicated before, from reputable sources, to give recommendations to the readers as to tips on things they can do to address fatigue because of COVID-19, and also trying to prepare something visually attractive. I think there's a department at AOC that's assisting us with that. And I think those things are still in process, and I'm not aware of any additional things besides that we would have to report.
All right. Any further questions or comments as to the work of the Virus Fatigue Committee or Working Group? I certainly appreciate those reports. One of the thoughts that strikes me as we go through the reports of each of these three groups is how the extent to which we're being called upon to address issues that are not part of our everyday areas of expertise. All of us on this task force consider ourselves, at least to some extent, to be fairly expert in the field relating to the operation of the North Carolina court system. But if you look at the titles of these work groups, each of these work groups is totally outside those areas of expertise. And I'm really grateful to the members of each of these groups for the great efforts they've made to gather information so that all of us and all of our local officials can be better informed about these areas that are, as I said, really not necessarily in our areas of expertise. And so thank you very much for that information. The next item on our agenda relates to our plan for the resumption of jury trials. As you all know, the Chief Justice has called upon us to formulate that plan and submit it to her as part of our work. Included in your current draft of the final report is also a current draft relating to that portion of the report with respect to our plan for the resumption of jury trials. Now, as we have worked together, one of the recurring phrases that we have heard and even spoken more and more as we go along is that the work of this task force is not something that could be described as one size fits all. As we focus efforts on planning to resume jury trials, we've found that that same warning very much applies to the resumption of jury trials. Not only with regard to different parts of the state having different concentrations of population and different caseloads, but also as to each individual district with respect to the various stakeholders that are represented within those districts. And in seeking to recognize the varying concerns of different stakeholders, we have received, as you all know, comments from different stakeholders that have demonstrated widely varying concerns about the resumption of jury trials. Now, at this point in time, in the current draft of what's in your present draft of what will be our final report, we have tried to include fair and accurate summaries of the input we've received from various stakeholders in this draft so that the local court officials that are reading this report and the Chief Justice to whom the report's being made will be very much aware of those varying concerns in the ultimate decisions that are made. Now, I recognize that it may be unlikely for us to expect to reach unanimous agreement on every point addressed by this plan. But I do hope that we can at least reach a consensus on the fundamentals of this report and at least fairly summarize the concerns that have been raised by various stakeholders so that the ultimate decision makers will be aware of each of those concerns as those decisions are made both by the Chief Justice and by local officials in deciding how to proceed with jury trials both on a statewide basis and in those individual districts. One of the other recurring themes that we've heard already today is the need for clarity. And a number of members of this task force have specifically asked that we make a recommendation of some sort to the Chief Justice as to a recommended date on which or after which jury trials may resume in the state, at least. Not necessarily dictating that they will resume in every district on that date. So at this time, I would like to ask, do we have any motion for consideration concerning that very point? Is there any member of the task force that would care to make a motion one way or the other concerning our recommendation to be made to the Chief Justice as to a date on which or after which jury trials may resume in North Carolina courts.
Billy West, with the DAs, I think we've been pretty consistent throughout that August 3rd is our preferred date. Has gone through our executive committee while also seeking input from other members of our elected district attorneys. So, I mean, obviously the plan we propose has more detail than just a date. But as far as a date, that has been our proposed date. Has been August 3rd, and then for some of the reasons we've stated in the plan, as well as possibly even some speedy trial or equal protection issues, we do not think that a differentiation should be made, at least on a statewide level, as to which cases can be calendared. Then that's certainly something that the local COVID team, as well as the local resident judges, could make that decision in consultation with their public defenders, defense attorneys, DAs, et cetera. But that would be our proposal as to a start date would be August 3rd, that DAs were allowed to calendar trials on that date.
Thank you, Mr. West. Is there any person who wishes to second that motion?
This is Robert Evans. I second the motion for the reasons stated by Mr. West. I think as I've looked through the rough draft of the recommendations, from my point of view, the August 3rd date is in effect and practicality nothing more than a planning tool. When you look at what, and as Judge, you mentioned all of the issues that go into this discussion that many of us are not expert on. The way I view this is whatever date we do agree on, and I support August 3rd, it's just a date for those of us who have to do this work to begin our thoughts and planning. And much of the work that we're going to have to do to get prepared to have a jury trial has really nothing practically to do with the date, but we do need a planning start, and I think that helps us towards that goal. But most of us, and even in my district, it's 3 counties, I can't foresee that we're going to be able to start jury trials the same time in all 3 counties, which is a point you just made. So I second the motion.
We have a motion from Mr. West, a second from Mr. Evans. Is there any discussion on this motion?
If I may, and the defense bar is equally as excited to resolve our cases. Many of the criminal defense attorneys, their business runs on resolving cases. They need to get them done. We have clients in jail that need the cases resolved, and they're going to be most anxious to have some of their trials heard. However, if we're doing an August 3rd date, I think that is too soon if we are saying that the August 3rd date is without the consent of both parties. I don't object to an August 3rd date. I don't know how it could be done any sooner, quite frankly. We were in a position.
Sorry, I didn't understand the last thing you said, Ms. Harjo. You don't understand.
I don't understand how it could possibly be done any sooner. I mean, we have so many protections that we need to put in place for not just the lawyers, but all the staff, the witnesses, the jurors. So while we are, as a defense bar, we want to resolve our cases as well. Our clients certainly do, and they're pressing us to resolve their cases as well. At the same time, unless we are assured that the protections are in place, I think requiring defendants and counsel to commence a jury trial starting August 3rd, when they have been without a period of time to conduct in-person investigation or interviews that have been necessary within the past few months. We've certainly been working, we've certainly been doing what we can by telephone, but it has just not been feasible to send investigators to particular locations to do the work in person that they needed to do. I'm not certain it's still going to be feasible in the near future. Lawyers have not been able to sit and talk to their clients in person. We've done all of our conferencing on video for the safety of each of us. And I think that's going to continue for a period of time. So my opinion is August 3rd, unless it's with the consent of the defense, the defendant, the defense bar, and the state, without the consent of both parties, at least for criminal trials. That's what I'm going to speak to, the criminal trials, because those are the ones I spoke about. I just think it's too soon. And so I would object to it, and I would urge you to, I guess, look at the concerns that are in the report. And I believe the concerns accurately identify the concerns that I expressed, and that were expressed by others. And I think that's the problem with saying that we're going to start, the DAs can start calendaring cases, trials on June 3rd without the consent of the defendant in criminal cases. Civil cases, apparently the civil bar is ready to go, and they're ready to go by video. And that's fine, and I can understand that. But I don't think we should be doing criminal trials by video. And so I would object to an August 3rd date.
This is Patrick Weed. I would agree with what Ms. Harjo said, and based on feedback that I've received from criminal defense attorneys at the outset. I think that the draft accurately and is well done, well written, listing out the concerns that criminal defense attorneys have expressed. I think the draft also does an excellent job of listing the positions of all interested parties, the prosecutors, the defense attorneys, and the civil bar as well. Page 19 of the draft at item 4H is a suggestion that for criminal cases, like Ms. Harjo said, if everyone is ready to go and everyone wants to proceed on August 3rd, I think that's fine, consent of both sides. But at the outset, some criminal defense attorneys mentioned not having trials until the fall, at the earliest, assuming that there's not consent to go forward sooner. And there has been specific concerns in the most serious cases, the capital cases and non-capital first-degree murder cases, and a recommendation that 4 to 6 months from the time that the stay-at-home order is lifted, or was, I guess, recently lifted the end of May by the governor, that time period is necessary in order to prepare. So there's a proposal in that subsection of waiting until the end of November to begin cases of that nature. I would recommend that if the task force believes a date certain is necessary, that we follow the dates on page 19, item 4H instead. But I also think that the way that the draft is listed right now, listing all the issues and the positions of each side is also an appropriate way that we can leave it and let the Chief Justice make what she believes to be an appropriate decision after reviewing the report, listing all of the information as the draft does. Thank you.
Thank you, Mr. Weed. And I also thank each of you for specifically mentioning the consideration given to your input. That was one of the questions I wanted to ask, was whether or not you felt that your input had been treated fairly in the summaries we've included in the draft. And please do not hesitate to let us know of any inaccuracies or anything that you consider to be an unfair or inaccurate treatment with regard to the input that you provided, because we certainly want to give a clear picture both to the public and to the Chief Justice of the feedback that we received from the various stakeholders. Is there other discussion on the motion that has been made at this time?
Judge Bridges, this is Kelly Myers, the TCA in Wake County. I also am in disagreement with the August 3rd date. I too think it is too early. We haven't even begun resumption of some in-person hearings yet. We're not even starting that until Monday. We don't know what that really is going to look like or entail. Additionally, I have a lot of concerns about how we're going to get an accurate pool of jurors and a representation of someone's peers when children are not back in school yet. And so parents are still dealing with childcare issues. While I know that's also a typical summer issue, I think because of this extended stay at home and teaching from home situation we're in, that you're going to have a lot of parents who are unable to serve as jurors come August 3rd.
I can just offer what I've read, because this was an important issue for the Chief Justice. I've tried to look pretty hard at it. It seems to me that whatever gets done in August is going to be a fairly preliminary sort of trial run for the whole process. And that means sending out the jury summons, dealing with the number, sending out more than normal, because you can expect a higher number of people who, for one reason or another, can't come. Getting them all together in a place. In some places, that's not possible. It'll have to be staggered groups, then doing the voir dire. It just seems to me that it's necessarily going to be a trial and error thing anywhere it happens, and to use that sort of trial and error technique in a serious felony or a murder case, that just doesn't seem to appear just. And it would seem to me that what lawyers on every side would want would be something that will withstand scrutiny at the appellate level and appears to the public to be fair. So I don't know that that leaving this thing up to a variety of judges, not that I distrust anybody, but it just seems to me as a policy matter, which is sort of the 30,000 foot look that we're supposed to be giving. It doesn't seem to be reasonable to me as just an ordinary lawyer.
This is Marsha Johnson, clerk in Harnett County. Just from a staffing perspective, I will have to disagree with the August date. It has come to light in the last couple of days that there are a lot of clerks that cannot follow the Chief Justice's recommendation of staggering shifts merely because of all of the courts that are being scheduled in their counties. So we've got a lot of counties that they've had in the last week or so, they've had to pull their entire staff back and they're not working the shifts. The Best Safety Practices Committee and their recommendations, they do recommend the staggered shifts. And I think August is going to be a little early. I think there may be some staffing issues to get all of that done by the counties that are trying to do the staggered shifts. And there is a risk with those counties that have brought all of their staff back. If there's a resurgence or there is any contamination, I think there was a county this week that had to close. There's been a couple of them lately that had to close to sanitize and then open back up later. So I think there's a possibility that there could be some staffing issues, and we're a little early in the game to me with getting back into it. So I think August is a little early. I think the clerks would prefer a later fall if this year. So I think there could possibly be a staffing issue with the clerks.
Thank you, ma'am.
Judge Bridges, this is Kinsley Craig. I'm a representative for the Court Management Group. My concern is more of a logistical issue. If we are to start back courts with jury trials that week of August, one of the things in the Chief Justice's recent directives is by July 1st, the COVID coordinators are to identify their alternate facility locations in the event that their current facilities are not capable of housing jury trial. You know, this is something that's going to be new for everyone, new for county management, new for those of us who work in the courts. And I'm very hesitant to say that a month's time between July and August is going to be sufficient enough to get the kinks worked out of the logistics in having a jury trial in an alternate location. In addition to, and I would have to refer to the clerks on this one, but for jury summonses, that summons I would assume or imagine would have to include alternate facility locations. So in the event that that information is included and then you find out halfway through working out the kinks in your alternate facility, that you may have to move to a different location. I'm just worried that that 4-week time period is just, it's not going to be logistically helpful.
All right. Other comments? Are there other concerns in favor of the date specified in the motion or opposed to that date specified in the motion? Is it the pleasure of this group to vote on that motion?
This is Robert Evans. Mr. President, I think we can call the motion and see what the sense of the committee is.
All right. All right. So that we can be clear on exactly what we're voting. Mr. West, would you restate the motion as you have made it?
My motion would just be that attorneys be allowed calendar jury trials beginning August 3rd, and that certainly once they have the authority to calendar, the capability of any case going forward would be subject to any ruling by the judge the case comes before. And we would also, I would require, or I would add in my motion that also, that the COVID team in each district should came up with a plan for the safe resumption of jury trials. I do want to say, while Mr. Harjo makes a good point, unless Mr. Evans feels differently, I think to say with the consent of all parties, that wouldn't be consistent with the directives we've been given from our executive committee and larger body. I think, our desire would be that the local resident judge who the case is before would make the ultimate decision on whether or not the case could go forward if there was some disagreement between the parties.
And I have seconded the motion, and I agree. To me, I don't see what the consent issue resolves. If the contemplation is that we're going to either have a date or not have a date, but that in each of our districts, we're going to have COVID coordinators who will bring forward all of the stakeholders to talk about the various issues in their district regarding the resumption of jury trials. There should be a consensus in each district as to when and how effectively they can be resumed. And so I don't think the consent issue is necessary. And I think it kind of violates what we've been talking about. And that is that we're trying to make recommendations and give people a template about how to go forward. We're not trying to dictate how people do that, but present a roadmap and give the chief recommendations. So I agree with Mr. West that the consent part of this discussion or requiring consent is probably not necessary and just adds a layer that's going to be irrelevant to the process as it goes forward.
Your Honor, this is John McCabe. Just coming in from the civil standpoint, I believe the way Mr. West just phrased his motion is a little bit different from how I at least heard it initially phrased. The second phrasing of it seemed to be specific to criminal cases, whereas I thought the first motion was both criminal and civil. I would request Mr. West just clarify that for me. Certainly from a civil lawyer standpoint, we would like to get civil cases going forward and would not like to have his motion limited just to criminal cases.
I'd be more than happy to accept that friendly amendment. I just we've probably got a little too focused on the criminal world. Yeah, civil cases would be included. Thanks, John, for bringing that up.
This is Patrick Weed. Perhaps we could vote separately on the criminal and civil issues. I think there are, like we've talked about with the technology and innovation sub-working groups recommendations. I think there are issues that are involved in criminal cases that are not in civil cases. The civil bar seems pretty unified in their belief that trials can resume in August, early August, and that is not the case in the criminal world. So I would propose that perhaps we could vote separately and separate criminal and civil and vote separately on those issues.
This is Kelly Myers, and I disagree. I mean, summoning jurors, calling in jurors, staffing courtrooms with a judge and a clerk and a court reporter and a bailiff, doesn't matter if it's a civil case or a criminal case. And we're going to need a lot of time to prepare to do this safely. I don't think it matters whether it's criminal or civil.
Ms. Myers, with respect to your opinion on this, when you say that August 3rd is too early, yes, do you have some other date in mind?
A hard date, I don't at this moment. I do think we probably need one. And I'm also more envisioning that we possibly recommend that the COVID coordinator certify or ensure that they have a safe plan in place, or the senior resident does, by a certain date, possibly. Because I think in some places it's assumed that the COVID coordinator is going to have a lot more teeth than they do. And we may not, those of us who are, COVID coordinators across the state may not be able to pull people together on an agreement locally as easily or as quickly in order to get summons out by August 3rd. Maybe September, but again, I would defer to the clerks on that for their staffing. And if it's a date, I think it needs to be made very clear that jury trials do not start until after that date, and then only after the local courts have created a safety plan for doing so.
As I understand it, the motion as it now reads would include the requirement of a local COVID safety plan to be in place in conjunction with a resumption of jury trials as part of the motion that requests a date of August 3rd. Is that correct, Mr. West?
That is correct.
Okay.
This is John McCabe. It was my understanding that it would be a district by district decision, not a statewide mandate. So certainly Wake County may have different considerations than Nash County might have, for example. So I think with that clarification, I'm okay with that proposal, but certainly understand and respect that people in Wake County or other more popular counties may not be in a position to resume jury trials at that time. The way I'm viewing the motion, it is not a mandate that jury trials start on August 3rd. It's just that's when we can start looking at doing it, so long as it can be done safely within the recommendations of this task force and the local bars.
That is certainly my understanding. We have another point we've said time and time again is we're not going to try and issue directives or mandates to anyone. We're simply going to try and serve as a resource, provide recommendations, try and itemize considerations that should be taken into account by local officials in making their ultimate decisions, as well as making recommendations to the Chief Justice in this report for her consideration. All right. Are we ready to call the question for a vote? All right. Let's proceed with the roll call vote at this time upon a motion that would allow, not require, the calendaring of civil and criminal cases for the resumption of jury trials on or after August 3rd, 2020, so long as the local COVID coordinator has submitted a COVID safety plan with respect to those jury trials in that district. Mr. West, have I fairly stated your motion? Let's proceed with a roll call vote on that motion at this time, please.
Judge Bridges?
I vote yes.
Judge Corpening?
I vote yes.
Judge Vincent? Mr. West?
Yes.
Mr. Evans?
Yes.
Clerk Johnson?
No.
Clerk Shingari?
I vote no.
Kinsley Craig?
Yes.
Kelly Myers?
Yes.
Mr. Cheek?
Yes.
Ms. Harjo?
No.
Mr. McCabe?
Yes.
Mr. Harrison?
No.
Mr. Weed?
No.
And Mr. Keister, have you joined us yet? I didn't see your name yet. Okay, Judge Bridges, that is everyone who is present.
Did I count correctly that the votes are 8 in favor and 5 opposed?
That was my count as well, but I might ask Danielle or others who are taking votes to double check my math as well.
Okay. All right.
Bridges, my notes are 9-5.
Oh, okay.
I must have missed one. Apologies.
All right. Our minutes will reflect that that motion passed. And we will, I suppose the next step will be to determine exactly how that gets translated into our report. As I mentioned previously, I would urge everyone to take and read this material. If you have concerns about how the material is being presented, please address those concerns by written request to have an item added to the agenda for next week's meeting. Now, let me say this with regard to the vote we have just taken. So far, we have tried to garner as much consensus as possible for everything we do with this task force. And it is clear that there is significant dissension on this particular issue. That may be a signal that we should give further consideration and see if we can perhaps tweak this matter in order to arrive at a greater consensus. So I would urge everyone not only during the next week to read and digest the materials, consider what sort of proposals you wish to offer or changes to our reports, including our report on jury trials, and to make written requests for adding those items on the agenda for next week so that we can decide whether or not we want to give further consideration to any of these points. Judge Corfening, is there anything you want to add on this point?
Yes, Judge Bridges, thank you. I think that unless something significant changes over the next week, if what we've just acted on is going to be submitted to the Chief Justice, I think that we need to find a way to convey to her that the heartfelt opinions of this task force vary as much as the written input that's included in our report as well. Because we're not at a consensus here, and I think that needs to be communicated to her. I know that she's wrestling with this issue, and I think it will be helpful for her to know that we've wrestled with it too.
I agree. Yeah. But there's some very significant concerns, and I understand and appreciate the need to set a date and try and move forward at some point in time. But I also want to see if we can address those very serious concerns that have been expressed by a number of people. So please give some further thought to that. Our next item on the agenda, I'll turn back to Judge Corpening for our plan and timeline for submission of our report, our final report.
Before Judge Corpening does that, can I just make sure that everyone understands that the intent is also to include the actual comments and the appendices? So to the extent that you all have submitted prior written comments from different stakeholders, the actual comments themselves will be attached to the report. So just want to make sure folks know that.
Thank you, Danielle. Judge Corpening, item 6.
Thank you. And Danielle, thank you for stating much more clearly what I meant to say. Grateful.
I'm sorry, Your Honor. I didn't realize you even said that earlier, so I was not trying to.
That's how unclear I was. Thank you. Because I do want to say, before I move on to item 6, that the work that all 3 committees have done is fantastic. The way that each working group has taken a deep dive into this work on very short notice is remarkable. And Judge Bridges and I, as we talk each week, are always amazed at the quality of the work that's coming out and how quickly it comes out. So thank you all for your work on that. And also on the jury trial issue, we really appreciate the input from all the different stakeholders, because this is a challenging issue, because it's not as simple as just saying, well, let's just put 12 in the box and try the case. There's planning that has to happen. And so there's some need for a date, and your thoughtful input on what that looks like is helpful. I'll also share that some of our conversation is it's easier to push a date back than it is to move a date up. And so whatever date ends up being, if it's August 3rd or if it's September or whatever, it's easier to push it back than it is to move it up. So thank you all for your input on that. We do need to try to wrap up our report that will go to the Chief Justice. Time has been our enemy since we were convened. Court expansion begins next week. That's varying across the state. I spent an hour on a call with all the chiefs just before getting on this call, and it's varying, but we're going to have more people coming in, and honestly, lots of folks are looking to this group for guidance, and I know that the Chief Justice is. So we've mentioned a couple of times in the meeting today that we want your substantive input by next Tuesday. And Judge Bridges, did I hear you say 2 o'clock on Tuesday?
5 o'clock p.m. on Tuesday.
Right. I just want to make sure that you and I were consistent on that. So by 5 o'clock next Tuesday, my suggestion would be that we meet again next Thursday to see if we can find some consensus. And then if there are major stumbling blocks, then we'll still have a week to get it in before June 15th. But we really need to get this to the Chief Justice for her consideration. All of you have done lots of reading. You have all looked at outside resources, at what other states are doing, at other best practices. But we really need to try to tie a bow on this and to get it to the chief, especially as we all try to send a message to the public that as we expand our operations, we're going to do it safely. And that we're going to be looking out for the people who come in our rooms. I know that's been the messaging that I've tried to convey in my courthouse just in the last 7 or 8 weeks, but that's a message that we need to convey. So that's the timeline that Judge Bridges and I would like to have. And again, we're really looking for substantive comments and not wordsmithing. But we're open to thoughts from the committee, but that's the timeline that we would like to set for trying to wrap up this portion of our work. There'll be more work that we have to do after that. But at least for this portion of our work, we'd like to bring that to a conclusion possibly next week, but no later than June 15th. Judge Bridges, other thoughts on that?
No.
Any comments from the group about the feasibility of that? Right, then that's our plan. And Judge Bridges, back to you on goals for next meeting and the date.
Okay. Unless there's some reason not to do so, I propose our next meeting be 1 week from today, next Thursday at 2 p.m., June 4th. And our goals for that meeting will be to finalize our reports from the 3 working groups. Hopefully have not only our final version of the plan for resumption of jury trials, but also work toward finalizing our final report. Now, with regard to our overall report to the Chief Justice, those of you that have had an opportunity to review the current draft may have noticed that there is a section. I may need to get help from Danielle in pointing me to this now that I'm looking for it on the spot. This section concerning budget considerations or requests that we may need to make of the General Assembly. And at this point, that section of the report is blank. I would urge you all to give some thought to that. I understand that the administrative office may be working on putting together some information for us in that regard, but we have not talked about that at all, other than some proposals that have been mentioned by the Technology and Innovations Committee, especially as the long-term solutions that may require action by the General Assembly. So I would urge everyone to at least begin giving some thought to those considerations because that may be something that needs to be addressed in our final report. That is my thought on where we need to be a week from now. Remember again to submit those considerations between now and Tuesday at 5 p.m. as to any item that we wish to address. And the purpose of that is not to limit discussion, but simply to try and provide some structure to our discussion process. Is there anything further that I need to be aware of that we have left out?
Judge Bridges, this is Jay Corpening. I would suggest that we have Danielle perhaps be able to get the draft of COVID-19 related funding requests that AOC is working on and share that with the task force.
All right.
I already have it. I saw that's where you guys were heading and I asked for it today, so I can share that for next week's meeting.
Okay.
Thank you, sir.
All right. Is there any further business that needs to come before the task force today? All right. Thank you, folks. Thank you very much. We've had a short meeting, but I think we've covered a lot of material. Hopefully it will pay off for us. So at this point, we will stand adjourned until next Thursday at 2 p.m.
Thank you, Judge Bridges.
Thank you.
Take care.
Thank you. Bye-bye.
Thank you.